So let's go ahead and get started. My name is Emily Sumner with Sumner Immigration Law. We represent clients around the United States and around the world with employment-based and family-based immigration matters. And I'm so glad that you joined us today. Whether you're joining us live, I'm glad that you all are here. And like I said, let's make this interactive and fun as it can be. And if you're catching the replay, that's great as well. And feel free to send us questions if you have questions. So the way that you can, like I said, the way that you can share questions to the extent that you have questions during the webinar is put them in the chat. At the end, we'll open the floor to questions. And I may, like I said, I'll try to keep an eye on the questions in the chat and answer them as we go along. Or I might say, oh, we'll address that in just a minute. I might not say it at all, and we'll address it later on. So let's go ahead and get started. So here's what we're going to talk about. What is an H-1B visa? An overview of the H-1B CAP registration process, status-specific considerations, ways to think about approaching your employer if you are an employee, a foreign national employee, or would-be prospective employee, the employer obligations, and what to do if you're not selected. We probably won't spend a lot of time on what to do if you're not selected because we typically have a separate webinar about that, and I publish a lot of information about that towards the end of March and into April. So we'll definitely cover that information as well. We're also going to cover potential changes that we could see with the Trump administration, a couple things that we've already seen. So everybody excited? Put it in the chat if you're excited. No one's excited. Okay. Yes, Attica's excited. Awesome. Thank you. Keep putting it there. Like I said, I want this to be as interactive and as helpful for you all as possible. If you also would put in the chat while I'm talking about what is an H-1B visa, if you would put in your chat like the number one thing that you want to get out of this, or the biggest question that you have, I think that would be helpful, and it'd probably be helpful for everyone else to see that as well. So what is an H-1B visa? Does anybody know? You can unmute yourself for this. Does anybody know what an H-1B visa is? Anybody want to share that?
I could go, Emily, if that's all right. Being on H-1B for the last almost 10 years. It's a specialty occupation visa that allows you to work in the US for a specific employer who has filed your petition.
Yeah, absolutely. Thank you so much for that. So an H-1B visa, as Vandana, and I don't know if I'm pronouncing that name correctly, said is a temporary visa. So when I say temporary, it's valid for up to 6 years, and it can be extended beyond that for professional positions in the United States. So what does that mean? The regulation says a professional position is a position that requires a minimum of a bachelor's degree in a specific field of study to enter that particular profession. That's really important. And then what is the H-1B cap? We'll talk about that in just a minute. And why did the government change the process? So all of this, or some of this we've already talked about, what is an H-1B? Importantly, a US employer has to file the H-1B. So it is possible, there's a set of regulations that came out in December, referred to as modernizing the H-1B system or the H-1B program. And it made it a bit more reasonable, a bit easier. I don't like to use the word easy in immigration law, but made it easier, a little bit looser for a person to self-sponsor. But you still have to have a company, you still have to have a way to pay yourself, but it is possible for the owner of a company to sponsor themselves for the H-1B. But regardless, there has to be a US entity to do it. You can't just come in as, for example, an accountant and be like, hey, I'm going to start my accounting business and I'm going to self-sponsor. There has to be a bit more structure to it. There is a numerical limitation, which is why we're having this conversation at all. That numerical limitation is 65,000 plus an additional 20,000 for US master's degree holders or higher. So who's eligible? We talked about this a minute ago. The position has to require a minimum of a bachelor's degree in a specific field of study. And Greg here asks, perfect timing, how closely does the degree need to align with your employment? The answer to that is it depends. So the modernization rules that came out in December, which by the way it's a set of regulations and they're still in place, even though they were promulgated is the official word, even though they were created during the Biden administration, they're still in place. We'll have to see what happens to them. I think they're going to probably remain in place. It's harder to undo regulations than like executive orders that have come out. Anyway, um, so in general, we look at what does for a position, that is potentially going to be an H-1B position. We look at, we meaning we as immigration law professionals and USCIS, so we do because USCIS does, they will look at what does the Occupational Outlook Handbook say that the position needs. Now, the Occupational Outlook Handbook, or the OOH, is a guide that's published online by Department of Labor. And if you look up the job title, whatever the job title is that you're looking up, there is maybe going to be an entry in the OOH for that job title, and there'll be a tab that says how to become one. That tab hopefully will say that this position requires a minimum of a bachelor's degree in a specific field of study, and hopefully the foreign national in question has that particular degree. However, that's not how real life works. And the OOH has not been updated, in my opinion, to reflect 21st century positions. So for example, if you have somebody, we have a number of clients in pharmaceutical development industry, for example. Sometimes those job titles in pharmaceutical development are a little different. It may be something that if you're not in that industry, you wouldn't have heard of it. But sometimes it's something that we can, the job title is something a little bit different, but essentially what they're doing is the work of a chemist, right? So if you look up chemist, and that doesn't necessarily have to be the job title that the employer uses, but if you look up chemist, if that's the basic job duties that we're using, they align with the position of chemist or the occupation of chemist. If you look that up in the OOH, fortunately, the OOH says that the position requires a minimum of a bachelor's degree in, guess what, chemistry. That's really straightforward. However, there are other positions that are not as straightforward, as you can imagine. Lots of positions in the 21st century either maybe don't require a bachelor's degree, and so those probably are not going to be good options for the H-1B program, or they do require a bachelor's degree, but they can be from seemingly different fields of study. So for example, for the position of clinical data manager, which is a pharmaceutical development type position, again, to draw from that industry, and we have clients in all different industries, but for that particular type of position, it's a position that obviously manages and analyzes a lot of data during the pharmaceutical development process. And because of the job duties that they have and the tasks that they do, first of all, if you look up clinical data manager in the OOH, it's not going to be there. It doesn't exist. That does not mean you can't file an H-1B. It means that we can't use that as a source, which can be a good thing. But if you talk to the employer about the degrees that they require, a lot of times the employer will say, oh, we need somebody with a degree in pharmacy or statistics. And if USCIS looks at that, you might think, oh my goodness, those are two totally different fields of study. How is this possibly a specific field of study? But we make the argument successfully. We've done this numerous times, and not just for this position, but others as well. We explain why the courses in those particular fields of study are relevant to the proffered position. So clinical data manager, obviously they need to have a lot of knowledge about pharmacy and the way that drugs interact and things like that, but they also have to have knowledge of statistics and data analysis and things like that. So depending on what degree they have, we can make that argument and it's accepted, it's okay. So that's a very long-winded answer to say it depends. So a big part of the strategy is coming up, working with the employer. And so this part of the strategy comes when we file the petition, not necessarily for the H-1B registration process, but you want to make sure the position is eligible and you're not just registering for no reason. But a big part of the strategy is making sure that we have an accurate job description, an accurate job title. Sometimes the employer will say, nope, this is the job title, it's not changing. Other times employers will say, yeah, we can use whatever job title you think is going to work best. But really it's the job duties and the job description. And then we look at what the employee has, the foreign national has, and map the courses and the degree that they have to whatever is relevant to the job duties. So my point is there is some flexibility. There's a lot of strategy, a lot of analysis and arguments to be made. There's some positions that just aren't going to qualify, right? If you look up in the OOH, for example, computer programmer, for example, it basically says that a degree is not required. Or there's some positions that will say a bachelor's degree is required, but it can be in anything. And then sometimes we can make that work and get creative with it. So I know that's a not very straightforward answer, but that's why I have a job, right? To make this type of thing work and to know we will tell you absolutely for a position, hey, we really don't think this is going to work, and I will not accept the case if I think it's not going to be approvable. But there are lots of times where we can be creative. We've had lots of experience previously with this type of position, and we can make it work. So what if you don't have, I'm actually not going to allow note taking just because I can't control what notes it takes. But this is being recorded and we'll send you the recording. So there are some situations where the employee either doesn't have a degree or they do have a degree, but it's not in a related field of study. That may not be the end of the road, because if the position, so there are two things you want to look at, right? Does the position require a minimum of a bachelor's degree in a specific field of study? And then what does the foreign national actually have? They have to have that degree in that field of study. But sometimes we can use their experience and or education to get what's called a credentials evaluation that says that the combination of education and experience, or sometimes just experience alone, is equivalent to a bachelor's degree in X, whatever the field of study is. Now, that's not going to work if, the position just does not require a bachelor's degree, but it can work. So the H-1B cap, like I said, 65,000. So this is for new H-1Bs available every year. So if a person has already held H-1B status, which we'll talk about in a minute, or if they hold H-1B status now and they're filing to transfer to a new employer or an amended petition or extension, then they're not counted against the cap. If a person is looking to fall into the master's degree category of the 20,000, the master's degree has to be accredited and not for profit. That's an analysis that we do every year for every case that we submit, or before we submit it, before we register it, because we don't want to we don't want to tell the government, yeah, this is a US master's degree, and then find out it can't, have them selected, and then it doesn't meet those requirements, accredited and not for profit. So we do that analysis. What is the new H-1B cap process? Does anyone know what I mean when I say the new? It's not really new anymore, but does anybody know what I'm talking about when I refer to the new process? You can unmute yourself and shout it out.
Yeah, I'm aware a little bit, Emily.
Okay, tell us.
Yes, it's about, I think before everybody had to kind of prepare the whole petition and then send the papers, and then they will kind of randomly draw and then
Yes.
send petitions that are not selected back to the employers. And now it's like you just have to register the names online with name, passport number and the degree,
Yep.
I believe. And then they do the draw, and whoever is picked up, then you have to send the paper to the USCIS.
Exactly.
Is my
Yeah.
understanding. Yeah.
So before the year 2020, thank you for sharing that. Before the year 2020, as Vandana just said, we had to prepare the entire H-1B cap petition as if we were submitting it to USCIS. So that means we had to get the LCA, the labor condition application, complete all of the forms, all of the supporting documents, submit an entire petition to USCIS in the hopes that it was selected. And if it wasn't selected, it was sent back. So the disadvantage, on our side, of course, is we had to, for us and employers and employees alike, everybody had to prepare a full petition for a case that may or may not be selected. And employers had to pay the legal fees for the preparation of the case, and then it could not be selected. So in this situation, it's much more streamlined. And this began in 2020, March of 2020. Nothing else was happening big in the world then, right? No big thing. That's when COVID hit, a little crazy. But we made it. So this is a streamlined procedure where, like Vandana said, employers register the beneficiary, and we help employers register the beneficiary into an online system. And the information, we'll talk about the information in just a minute, but it's really streamlined. It's not a full petition that we submit at all. The registration period is in March. It's usually for about 2.5 to 3 weeks. And it opens, the USCIS has not decided to announce the dates yet. Usually they do that in February. So as soon as we have those dates, we'll share that with everyone. The registrations are employee specific. That's a change from last year. So before last year, the registrations, rather the selections, were employer specific. So now the registration, not the registrations, the employer has to register still with the specific employee's information. So you can't just say, yeah, I want to fill a slot for 5 vets this year and not have any idea who they're going to be. You have to have specific employees and their passport numbers and that everything. And likewise, an employer has to do it. You can't just say, yeah, let me register and then I'll find an employer later. You have to have an employer, but the selection will be based on a person's unique passport number. That means that, let's say that John Smith registers in the H-1B lottery and he had 2 different employers register for him. That means he has the choice because his name is selected and because 2 different employers registered for him. That means he has the choice of having employer A and or employer B submit an H-1B petition for him. So he's taking up 1 slot instead of the 2 different employers taking up 2 different slots, if that makes sense. And if it doesn't, don't worry, just know that it's a lot. I think it's a really positive change. And we'll see that reflected in the numbers in just a minute. The registration fee did increase this year. It was $10 for the past 4 years, and now it's $215, quite the increase. The lottery process is there's a random selection of H-1Bs after the registrations, random selection of registrations starting in or at the end of March. And then we have 90 days to file the petition. So when I say the registration or the selection is done at the end of March, we should have the selections, the information about who was selected by the end of March, by March 31st. As I said a few minutes ago, there are 65,000 slots available just in general for like regular H-1B registrations, and then 20,000 for US master's degree holders and higher. So the way that it works is USCIS will conduct that regular lottery first and select 65,000. Everybody's in that pool. And then for everyone who was not selected, they'll take out the US master's degree holders and select 20,000 of those. So US master's degree holders have 2 bites at the apple, so to speak, but it's not done separately. It's not like USCIS does the first lottery of 65,000 and says, hey, here are the 65,000 that are selected, and then we're going to do the master's degree. It's done all at once. So you're either selected or not by the end of March. And then we have 90 days to file the petition after selection. So we have to file between April 1st and June 30th. So 65,000, we talked about this. It's possible that there would be later selections or a second selection, a second round. That did happen in both 2023 and 2024. It was in late July that they announced that they did not receive enough petitions to fill this basically 85,000 slots that they have available. So there was a second round. It is possible that will happen this year, but it's not guaranteed. It just depends on how many people register, how many people are selected, and of those, how many actually file. And we won't know until July if that's going to be the case or not, or potentially later. So some status-specific considerations. One is, have you been counted? Every year we have this amazing event where an employer says, hey, I want to register employee Jane Doe in the H-1B lottery. And we always ask for, their immigration status documentation. We ask questions and we find out that Jane Doe has already been counted against the H-1B lottery. It's just that she's currently in H-4 status or whatever, some other immigration status, and wants to come back to H-1B. So if a person has previously been counted against the H-1B cap, you're not counted again and you don't have to register. So just keep that in mind. There is something called the H-1B gap. So foreign national students who are working in foreign national students who graduate from US institutions in the United States are eligible for OPT, for 12 months of OPT, meaning optional practical training. Basically, they have a work permit to be able to work in the US for up to 12 months. If your field of study is a certain field of study, meaning STEM OPT, meaning it falls within this list of approved courses for STEM, then you can get what's called a STEM OPT extension for another 2 years, so potentially 3 years of status. There is something for the H-1B gap. That this is pretty amazing. So let's say that you or your employee have OPT, and that OPT, that permission to work, is going to expire in July of 2025. Let's say July 1st of 2025. There is a provision in the regulations that says if you meet certain requirements, which are here, that you can extend, or that work authorization will be extended automatically as long as you meet these conditions. When I say extended automatically, H-1B status cannot begin until October 1st. That's when the new fiscal year starts for USCIS. So that's why H-1B status starts October 1st. It cannot start before then by statute. So if we didn't have this cap gap provision, there would potentially be a break in work authorization, right? It's possible that the person whose current OPT expires on July 1st, 2025, would then not be able to work between July 2nd and October 1st. However, this cap gap regulation, that's in the regulations, it covers that bridge. And as long as you are on invalid OPT status, you file for a change of status, not for consular processing. It's a box that we mark on the forms. And as long as you file before your current OPT expires, you are eligible for that cap gap extension. Importantly, that rule that I keep mentioning, the new regulation for modernizing the H-1B program, extends H-1B cap gap. It used to end September 30th. So then, like in August, we'd have to find people, look through our list and see who doesn't have their petition approved and they're relying on the cap gap, and recommend they upgrade to premium processing, which is when you pay an additional $2,800 to $2,805 to the government, and they make a decision or issue a request for evidence within 15 business days. Anyway, the cap gap is now extended until April 1st of the following year. So it gives us a lot more time, which is amazing. STEM OPT. So STEM OPT, like I said, if your field of study, if you're a foreign national student on F1, or if your employee is, and your field of study falls on this list, it's not every field of study that seems like it should be within STEM. So I've had, for example, dentists who don't qualify. I've had veterinarians who don't qualify just because of the code on their, the field of study that they have isn't on this list. Anyway, if it is, then you're eligible for a STEM extension. I would not rely on that, meaning I would not say, oh, I or my employee have another 2 years to work in STEM OPT, so let me wait and register them in the H-1B lottery in year 3. Because the chance of being selected in the lottery, of course, depends on the number of people that are being, that are registered. But the past 2 years, it's been 26%. So you don't necessarily want to give up. You're giving up 2 years. If you have STEM OPT, you don't want to give up the first 2 years if you can. Sometimes you don't have a choice, but you don't want to give up the first 2 years just thinking, oh, I'll do it when I'm in year 3 of STEM OPT. CPT stands for curricular practical training. Just be aware of that. That's something that we always ask clients about. It is designed for situations where a person is taking a course or a set of courses that requires hands-on experience, like an externship, an internship, a co-op experience, and it can be used legitimately. It can also be misused, either intentionally or unintentionally. And there are certain universities that are known for being very loose in their interpretation of the regulations and kind of giving it, I think, maybe when they shouldn't. And USCIS is aware of that, and they will issue pretty tough requests for evidence for individuals on CPT. So it's just something to be aware of and make sure you're using it correctly. So what are the implications of the registration system? We were saying before, we had to file the whole petition with USCIS. Because we don't have to do that anymore, in theory, there are more registrations than there would be if we had to submit an entire petition ahead of time. There's the danger of registration without proper analysis. It could be that a person is registered for the H-1B lottery and they don't really qualify. They have a position, either they have a position that doesn't require a minimum of a bachelor's degree, or they don't have that bachelor's degree in a specific field of study, and they're selected and they take up a slot, and then they either don't file or they do and they're denied. And then the timelines have changed. Fortunately, we've stopped for this kind of seeing this, but the first couple years, we would inevitably have employers contact us after the registration has closed and be like, hey, I'm ready to start, because the H-1B cap process, because it used to be we had to file really within the first 5 business days of April. Now it's, for a shortened window in March, so it's a bit earlier. So we have seen, these numbers are pretty interesting, I think. In general, we have seen an increase in the number of registrations. This is a historical since 2016. the number of petitions received. So these years, 2016 and 2019, remember that's when we had to file the full petition with USCIS. I'm just checking the questions here. So the first year of the new system, it only jumped up, roughly 73,000 more petitions. But then look at that in 2023. It's so many, almost 800,000 registrations. And when I say selected here, this is how many petitions or registrations rather USCIS selected. So remember, they will select more, obviously, than this 85,000 because people will register and then not proceed for whatever reason. And that's why I say there's sometimes a second round because USCIS will guesstimate, okay, how many do we need to actually select in order to fill the slots? But sometimes they're wrong and they'd rather underestimate than overestimate. So they'll do a second round. They may do a second round. It's not guaranteed. So last year in 2024, there were about 480,000 registrations and USCIS selected 135 of those. We already talked about that, the danger of registration without the proper analysis. So timelines. Bronwyn, this answers your question of timelines. So this is an estimate of the timelines. In general, if you can let us know now, between now and February, that you want to proceed, we would love to go ahead and get started. We already have several clients who have already submitted, some of whom I think are on here, that have already submitted their signed the engagement letter, which is the contract that says, what the fees are, and have already submitted the information that we need, which is amazing. If you haven't done it yet, it's okay. You are not behind. You absolutely have time. Do not worry. We will send out information in our email newsletter as soon as we have the dates, the registration dates, and give more specific deadlines, more concrete deadlines. But generally, we would love to have the information at least by mid-February. So if you're still having conversations with your employee or employer, depending on who you are, you still have time to do that. But we'll set specific concrete deadlines as soon as we have the specific registration dates. We register the cases in March. Like I said, we have the notification of selection by the end of March. When I say notification, the notification is online on the USCIS portal that the employer has access to and that we have access to. And we get an email supposedly from USCIS, and we always check the portal to make sure. So the employer would go to us and to the employee. Greg says, why were so many selected? For example, 188,000 plus if it's capped at 85,000, because so many people register and don't end up filing. It's a big number, right? But that's why. Or they either end up not filing or they do file and it's denied. The denial rate, I don't know off the top of my head, the denial rate for H's, in general, it's not high. It's definitely higher for other visa classifications like the L1. And knock on wood, and this is not a guarantee by any means, we have not had one denied. I can't remember the last time we had one denied. But we also do a really careful analysis and we don't accept cases that we think will not be approved. But that's the reason. Either they didn't proceed or the case was denied. So we filed the cases between April and June, and then you have a decision anywhere from April to November or beyond. I think we still have one CAP petition pending right now. So what can we do for you? The pre-registration CAP analysis or a case analysis. If you wanted to have a detailed analysis of the, what SOC code should you use? That's the standard occupational code. It's part of the case strategy. In other words, we can develop a case strategy. There is a fee for that. If we do that before we register. That being said, we do have everybody that we register for, we have an initial conversation about what's the job being offered, what degree do you have, just to make sure we're not registering for McDonald's workers. There's nothing, wrong with being like a cashier at a fast food restaurant for sure, but that's not going to be approved. So we make sure that we are not registering cases that aren't going to be approved. But if you wanted to have a more in-depth strategy session, there would be an additional fee for that. The electronic registration, we handle that for employers. It is, we try to make it as streamlined as possible. We have a website that on our page or a page on our website where we gather the information that we'll talk about in a minute from the employer and employee. We confirm it. Like I said, confirm that the master's degree is when it's going to be eligible, if that's your situation. And then we prepare and submit the selected petitions. So if you are an employee, so they reject them even if selected in case they reach that 85,000. So yes, we have a question that says, would they reject them even if selected in case they reach that 85,000? I'm not quite sure what the question, can you clarify what you're asking?
Sure, sorry. So they select, 180 or whatever the number was because they expect not everybody's gonna file.
Hmm.
But what if more than the 85,000 actually files? Um, so
Yeah,
anything above the cap, would they accept them since they selected them or?
yes, yes, they would
Okay.
accept them since they selected them. Yes, so
Okay.
it's not an exact science. And I don't know how they like approve that or work that out legally, but they do. But yeah, they wouldn't say, oh, they wouldn't say your case is selected and then turn around and say, oh, just kidding, we have enough now. So if you're selected, you're selected. So approaching your employer, if you're an employee, a foreign national, so things that you should kind of think about, are you currently or employment, but before a company hires a foreign national, there's certain questions that they can and cannot ask. They can ask, are you currently eligible to work in the United States? Do you now or in the future require sponsorship to continue working in the US? And they can give an example like H-1B. I really recommend that everyone be as transparent and truthful and straightforward as possible. So they're not, if you say, if as a foreign national, if you say that no, you don't need sponsorship to continue working in the US and you really do, that's not going to be a fun conversation to have down the road, right? When you want H-1B sponsorship. So just because you say, yes, I need sponsorship in the future, supposedly, and I know in practicality, it's different, but in reality and per law, not in reality, per law, an employer is not supposed to not hire you just based on the duration of your employment authorization document. So in other words, if you said yes to that question, but said, hey, I can work right now, I can work for the next, have this work authorization that's valid for the next 2 years and I can extend beyond that, or, whatever the situation is, that is not a reason for a legal reason for an employer to not hire you, but they also don't have to sponsor you for the H-1B. There's not an obligation for any employer to sponsor someone for an H-1B or other visa application. The employer might want to wait. So let's say that you have this conversation and you say, yes, I do need sponsorship in the future, but I have the OPT and then I'm eligible for STEM OPT. The employer might say, all right, let's wait and register you in year 3. That might be a conversation that you want to have to kind of self-advocate and say, here are the advantages of registering multiple years, and here's the cost. It's really not that big of an investment, at least to register in years 1 and 2 and 3 if you need to. I get it. Practically speaking, you may be so grateful to have a job offer and not want to have that conversation, about sponsorship, and not advocate for yourself. And I get it. There are practical considerations for sure. But if you're comfortable doing it, it might be, the worst they can say is no. And it might be worth having that conversation and saying, hey, here are the advantages of registering now versus waiting until year 3. So a common question, a great question is what information is needed for the registration? All of this information is on our website, and we'll share the link to that page that has the H-1B cap information. But the information from the employer for registration is the legal name, the tax ID number, the primary US office address, and the person who's going to sign and their contact information. The information from the employee is this information: name, gender. We need information about your degree, date of birth, country of passport, passport number. That's the information we need. We would have a separate conversation ahead of time. So we would have a separate consultation ahead of time, before we get to the stage to talk about, like I said, what is the position that's being offered, and some information if I'm not aware of the company already. We represent companies that hire foreign nationals all the time. And so I'm familiar with them, but we also take on new clients that we've never worked with before. So anyway, information about the company is relevant as well, just to get an understanding. And like I said, make sure that you're eligible for the classification. The H-1B filing itself is employer driven, meaning we need information from the employer. They're the ones that review and sign documents, and they make certain attestations. So when an H-1B employer or potential employer says, hey, what do I need to do? This is it. So documentation, we need corporate documentation. And again, you just have to give it to us once and then, update it as needed. But things like the address, the tax ID number, the number of employees, things like that. We prepare the forms based on the information from the employer and employees. So we prepare the forms for the employer to review and sign. That means no one has to go online and figure out, okay, which version of the I-129 do I need? What supplements do I need? Do I need this LCA? Is it an LCA or 9089? We do all that, so you don't have to worry about that. The employer, this is important, the employer has to pay the H-1B legal and filing fees by regulation. So it's not a situation where the employee can pay, it's not permitted by regulation for the employer to pay and then the employee to reimburse them. None of that is permitted. The employer does make attestations when they submit the LCA, or when we submit for them the LCA, the labor condition application. That is a form that we submit to Department of Labor that's required to be certified, approved before we file the H-1B petition. And on that, the employer is attesting that they will pay the prevailing wage or the actual wage, whichever is higher. Prevailing wage is a wage set by Department of Labor, and we can help you figure out what that would be. They're testing that there's not going to be an adverse impact to existing employees. They have to attest that there's no labor issues like a strike or lockout, and that they will provide return airfare home to the foreign national employee if their position is terminated before the end of the current H-1B period. So the employee information for the H-1B filing is things like copies of their degrees and transcripts, credentials evaluation. If you have a foreign degree, we can help you with that. Documentation of your immigration status, like your passport, visa, I-94, that type of thing. So if you're not selected, like I said, I'm gonna not cover this in a lot of detail because we'll have a lot more information about this later. If we're not selected, you can think about, you may have more time depending on what your current status is. You can potentially register again next year. There are CAP exempt employers, meaning there are certain employers who are exempt from the H-1B, from this numerical limitation, namely universities and certain nonprofits that have affiliations with universities and institutions of higher education. In addition, certain government research organizations and nonprofit research organizations. So it's a possibility. There may be another non-immigrant visa option for every letter of the almost every letter of the alphabet. There's a different visa classification and then subclassifications within that. Sometimes a person will start the green card process when they're not selected in the lottery. It's not ideal because it takes a long time, but I've had lots of clients do that over the years. You could potentially work remotely and set up a strategy to come back to the US later. Again, we'll talk about that more in more detail after the registration period. So upcoming changes. I have mentioned a couple of times the recent H-1B modernization rule. And I mentioned a couple of changes that have come through that. I think the big things there are, one thing I didn't mention with that, and it goes to, I think it's the question that Greg had earlier, which was how closely related does the degree have to be to the proffered position? And the answer, I gave this kind of long answer. It was like, it's strategic, it's, we have to do the analysis. And that's kind of put into the regulation. It's been kind of in practice. That's what USCIS has accepted, but they put it into the regulation, which is reassuring for us immigration attorneys. We love regulations sometimes. But it's in the regulation that USCIS should look at the actual course of study taken, not necessarily just the degree title. Because sometimes the courses, if you look at the coursework, and we've done this before, we've taken the job duties of the proffered position and the list of courses, and we've mapped them and said, hey, this position, this course, and whatever it is applicable, directly applicable to this particular job duty. And we go through course by course and duty by duty and map them, tie them together. So that's in, they don't put that in the reg to say, create a map for us, map it out. but it's saying that they should look at the specific courses and not just the job title. We talked about some of the other changes already in the modernization rule. I think there's going to be a lot of an increase in compliance during the Trump administration. That was definitely a feature, let's say, of the first Trump administration. So there were more site visits, meaning an officer can come to a USCIS officer, or you can be audited by Department of Labor, but an officer can come to the work site, meaning the site that, as the name implies, the site that's listed on the H-1B where you're saying the foreign national is going to work, and ask questions of, the receptionist, or the work site might be that person's home. Yay, you have an officer showing up there. So we have information available on that, on kind of how to deal, what to anticipate, and we'll be putting a lot more out in the coming weeks and months. But I do think compliance is going to be a big thing. So it means, yes, site visits, but it also means things like paying attention to changes in the H-1B petition. Not the petition, sorry, in the job offered. So if there are changes to the job duties, the salary, the corporate structure, the job site location, please, please, please have a conversation with us. We are happy to have a conversation and either confirm, oh, that's fine, nothing needs to be done, or to help you walk through whatever does need to be done. Sometimes it's an amended petition. Sometimes it's just updated paperwork in your internal files, but we want to make sure that that's all up to date and all the T's are crossed and I's are dotted, to make sure that you're in full compliance. Stricter adjudications, I think in general, we'll see stricter adjudication standards. We definitely saw that during the first Trump administration, although we've seen that in other administrations as well. I remember during particularly the second Obama administration, for whatever reason, we had a lot of requests for evidence and notices of intent to deny. I'm not saying that's going to happen for every case, but they're going to make things a bit more difficult. And it could be that the Trump administration would make changes to the required wages. I talked a minute ago about the prevailing wage, which is the wage level set by Department of Labor, and it's possible that they would change those wage structures. We would have, hopefully, advance notice of that. I was going to say we would have advance notice of that, but you never know what's going to happen. But we should have notice of that if and when that happens. So, ways to stay updated. If you scan this QR code, and I promise it is safe to scan, my husband's in information systems, and he was like, Emily, no one's going to want to scan that, because I didn't know it was unsafe to scan QR codes. But anyway, I promise this goes to our website, a page on our website that has links to all of these things: our YouTube channel, my LinkedIn, Instagram, a link to sign up for our newsletter, the website, obviously our Facebook account, and a link to sign up for our, a PDF of these slides. And like I said, we'll send the recording to everyone. So I'm going to open the floor now. You can either unmute yourself and ask questions, or you can put them in the chat, and I'm happy to answer any questions. I should have said at the beginning, none of this is legal advice, and I can't give specific legal advice in a question. So if it's very fact specific, I might say, sorry, I can't answer that. But I'm happy to answer any general questions. You guys have asked some great questions so far. So feel free to unmute yourself if you need to go. I totally understand. While you're gathering your questions, I'm going to look at some of these that are on here. Yes, Suresh asks, is the H-1B visa granted under the Conrad 30 J1 visa waiver program cap exempt? And the answer is yes. If you don't know what that's about, don't worry about it. It's a specific program for physicians who did their residency here and are subject to a 2-year home residency requirement. Very specific, but yes, those are cap exempt. Good. Anyone else have any questions?
Hey, Emily,
Emily?
can you hear me?
Sorry, I think I spoke over someone.
You can go.
So I have a quick question regarding the visa stamping. So I understand we're covering the H-1B for the coming year, but do you know if there's any new directives for the people going out of the country for the stamping after the visa is approved, or is that too soon, for us to No, because nobody knows the trend, how it's going to go, since the new
Yeah.
government just came to the office.
Yeah. Sorry, I don't know if you just saw me roll my eyes, and that was not at you for sure. That was at the fact that yes, we already have guidance on that. So, as you all know, the presidential administration changed on Monday, and they were very quick to issue, I think it was at least 13 executive orders just about immigration between
Mhm.
Monday and Tuesday of this week. So we've spent a lot of time reviewing all that, and that's a great question. There are two executive orders so far that kind of touch on that. One is an executive order that's really short, and it's directed to the US Department of State, which of course is the agency that to get a visa stamped, you have to
Mhm.
leave the United States, go to usually to your home country, apply at the US consulate to get the visa stamped. Usually there's an interview, sometimes they waive the interview, but the bottom line is there's an executive order that basically said to Department of State, hey guys, review your policies and procedures and the foreign affairs manual and everything, and within, I think it says a reasonable time, update it to make sure that you're putting America first.
Okay.
And that's the extent, basically. I mean, I'm summarizing it, but that's like it was not very clear what that means to put America first. We
Mhm.
saw that, this is not the first time we've done a Trump administration, and I'm not saying everything's going to be the same. I'm not saying don't worry.
Right.
But I do think that they'll have stricter, higher adjudication standards, and I think more delays with visa processing, and I think just in general, we'll have longer processing times in general for immigration. The second
Okay.
executive order was on enhancing vetting and screening of visa applicants. So that's something that we definitely saw again in the first Trump administration. That does not mean every single person who goes to apply for a visa is going to have extreme delays and be denied a visa for sure. But it does basically direct Department of State and other agencies to have, let's say, higher, stricter adjudication standards for adjudication to be stricter. Now, what does that mean in practicality? In practicality, I think for some people, it's going to mean longer processing times, for others not. Not every person who works within the Department of State is going to actually adhere to this. I'm not saying they're going to like just disregard it altogether, but it's going to be implemented at various levels, right? Depending on the particular consulate and a variety of factors. But we'll have a better idea of how that will play out once we've been into the administration for a few months.
Okay. I am that. I mean, I think we are kind of looking, we want to like basically watch, what the trend is because nobody has really gone out for the
Right.
organization that I work for right now. But I just wanted to know if there's anything that we need to keep in mind. If anybody, because I mean, I know there are new policies and procedures, but if somebody has to go for stamping, they have to go. You can't really like,
Exactly. Exactly. So
right.
I'll try to remember to put a link to this in the when we send out the recording. I actually did another episode with somebody that I know from LinkedIn on the executive orders. I did it on Tuesday night, like right after everything happened.
Oh, okay.
And this is the third point that I talked about.
Okay.
So we'll try to remember to send a link to that. And I'll also post it. I'm going to repost it actually today on my personal LinkedIn profile. If you want to check that out, that video will be there as well. The other thing that is not super great with that enhancing the vetting, I call it extreme vetting, is I think they are setting the stage. If you look at I don't think I have it on my desk anymore, but if you look at the language, it says something like it's directing the Department of State to look at the countries for which there's
Hmm.
limited security information available
Right.
and seeing if we need to prohibit individuals from those countries from entering the United States. I don't think that's going. The last time that happened, it was called one of the travel bans. It was called the Muslim travel ban. So there are political, diplomatic considerations as well. Like in other words, I think it would be really, really huge. Not I
Okay.
think it would be huge if the Trump administration said, "Hey, we don't have enough information from India, so no more visas for Indians." That would be catastrophic on a huge level. And I'm not saying it's not catastrophic to deny anyone entry, right? It's
Correct. Yeah.
huge for anyone. But we'll have to see how it plays out. I don't anticipate that it's going to be. I think the travel bans will be similar to what it was before, which was catastrophic enough.
Right. Will it also kind of impact like people who already have stamping? How is their travel is going to look like? Will they have any problems or they'll be fine if they already have a visa on there? passport? I'm just
I
curious to
never
know.
like saying a person will be fine because you just never know. But I know what you're saying. I think that if you have a valid visa and you don't need to go for stamping, then you should be able to enter, as long as you're in valid status and you have the
Correct.
documentation, it should be okay.
Okay.
I do highly recommend, and I say this all the time, no matter who is in office, I say talk to your immigration attorney before you leave the country, please, because
Correct.
we're happy to help you make sure that you have what you need. Even if you don't have to go for visa stamping, we want to make sure that you have, a valid visa and that you have all the documentation that you need to enter the United States. So
Correct.
send an email to your immigration lawyer, and let them know, give them a heads up to make sure that you're good to go. But if you don't need to have a visa stamped, then I anticipate it would be an easier process than if you do.
Okay, my last question. I know they have a pilot program for the stamping, within the United States. Do you know how far that have gone, or it's still in the they're still testing the pipelines? I don't know,
Right,
no.
same. So they had the pilot program and it seemed to go well. We had a handful of clients that were able to participate. It was very, very limited, as you probably remember. So the pilot program, by the way, for anybody who doesn't know, is a Department of State pilot program that allowed a person to renew their visa. And it had to be a renewal. It couldn't be a first initial
Right.
stamping, but to renew their visa here in the United States without having to leave, which is amazing, would be amazing. But is a very limited program, only for individuals from certain countries, only certain visa classifications, and it ended. I do not think that is at all a priority of the Trump administration. I don't think
I
that's,
know, yeah,
it could come back later, when
yeah.
in another 4 years, sure. But I don't think it's going to be a top priority.
I just wanted to ask because I think initially, even for the pipeline, the pilot program, they have defined the, months and and the
Yes,
dates. Like if somebody has gone for stamping during that time, then they can apply,
right,
based on the country and the duration. So, okay.
right. Yeah,
All right. I think it'll be interesting to see how next 3 months folds, for a lot of these things. And then we'll have more,
we
examples at
will.
hand to like decide, So,
Yeah, for sure.
yeah. Thank you, Emily.
Galaxy, yeah, go ahead.
No, that's it. I'm good. I don't have any other questions. Thank you so much.
Okay,
Very
absolutely.
helpful.
Did anyone else I have some questions here, but anybody else while I'm reading those have a question?
Um, Hi, Emily. It's related to our discussion yesterday as well.
Uh-huh.
I just wanted to know because we spoke about extending my B2 visa at some point. At the moment, it expires in the 2nd of June, and I think I remember you saying that it'd be best to extend it. You wait until May to extend it, and I could get another 6 months while I wait for this one to go through after filing. Does it make a difference whether I extend it in May or earlier? Can I say I want to extend it? Will they extend it from the point that it would have expired?
Yeah, you can. So we can talk about this separately, of course, but you can request a start date you can request whatever start date, not whatever you want, but you can request a start date like the date after your current stay expires.
Yep.
Yeah, you can do that.
All right. And my wife on the ESTA visa, that can't be extended. Is that correct? I just want to check.
Yeah, if you're on ESTA, you can't change status.
Okay. All right. Great. Thanks.
Sure. Somebody asks, will there be a point-based green card system implemented like in Canada? I don't know. That is not what we've seen as a top priority of the Trump administration in terms of immigration. The focus right now seems to be on compliance. Let's say, when I say compliance, I mean individuals who are here without documentation. It seems to be that, and enforcing the border and things like that. And there have been, like I said, the birthright citizenship that came out. That's in the episode that I said I'm going to post on LinkedIn in a minute. But anyway, I don't think it's a top priority, but it's possible that they would try down the road to roll something like that out. But it's not on the agenda as of right now. Well, I want to thank everyone for attending. Please feel free, like I said, to scan this QR code and further connect with us. Feel free to connect with me on LinkedIn. If you have any questions or if you are interested in starting the H-1B process or any other immigration process, feel free to contact us. You can go to our website and contact us, or you can call us at 804-396-3412 or email us at info@sumnerimmigration.com. Thank you so much for joining us, and I hope everybody has a great rest of the day.